recent charges filed against the Chief Justice of Nigeria, Justice Walter Onnoghen, by the federal government for false declaration of assets, Nigerians have continued to react to this development. Barrister Agbuegbulam Eric, in this interview with our correspondent Uchechi Nlemowa, illustrates the implication of removing the Chief Justice of Nigeria from his office build up to the 2019 election and its impact.
The federal government on 10th of January filed charges against the Chief Justice of Nigeria, Justice Walter Onnoghen, accusing him of false declaration of assets. According to the federal government, the CJN partially declared his assets in 2016 against the provision of the law. Many Nigerians have expressed their concerns to this development. Some believe that the trial of CJN is a political plot to remove him ahead of forthcoming elections. The People's Democratic Party PDP believes that it is part of plots by the APC-led government to destabilize the judiciary so as to rig the 2019 general elections. And according to presidential candidate Atiku Abubakar, the move against CJN falls his suspicion of President Muhammadu Buhari's growing desperation concerning the forthcoming elections. The Nigerian Bar Association and many prominent lawyers have also condemned the plot to remove the CJN. In this interview, Barrister Agbuegbulam Eric reviewed the legal boundaries of Code of Conduct Tribunal.
The Code of Conduct Tribunal is an agency set up by law but under the presidency. It is given a legal cover, a legal standing, but it is not one of the courts mentioned in our constitution. If you check the constitutions where the orders of courts are listed, the Code of Conduct Tribunal is not listed as part of the courts of records of this country. Now, to that extent, I am at a loss at where they derive their current claim of jurisdiction with high courts and co. Yes, agree to the fact that there's other provisions of the law that allow matters originating from them to go straight to the Court of Appeal for the purpose of appeal and adjudication. But the contention of whether they are of the same coordinate jurisdiction with the high courts and state high courts, it's one issue that has not clearly been dealt with in our law, in our courts. Having said that, it is known in the legal practice, in the legal system, that when issues of jurisdictions are raised in courts, it is a very fundamental that all other issues are stepped down for the purpose of jurisdictional argument.
According to Barrister Eric, Nigeria is not practicing separation of power, which is the Nigerian system of governance, hence the national issues.
What is happening must be understood clearly by every rational and reasonable Nigerian. First of all, we should not forget that we are in a democracy where we practice the presidential system that prescribes for us a system of government where they have three separate autonomous arms of government. You have the executive, you have the legislature, and you have the judiciary. These are the three arms of government that runs the Nigerian state. And our system of governance is based on absolute separation of power. Each of these organs of government have their different functions and rules clearly well defined by the constitution of the country. It defines the way you come into the office, it defines the way you go out. Anything short of the prescriptions of these of the constitutional provision for these offices is to the extent in which it's practiced null and void and confusion to the country.
On whether the CJN has the right to refuse to appear in court, Barrister Eric stated that the CJN was never absent in the court since his lawyers were there to represent him.
Technically speaking, the CJN has already appeared before the tribunal, but the mere fact that his lawyers, his attorneys acting on his behalf have appeared in court on his behalf, means that technically the CJN has appeared. All he just requires, because of the nature of the charge, which borders on the criminal, is a criminal charge, which our law requires that whoever is charged in that circumstance must appear in person. Otherwise, the CJN has appeared.
He also clearly stated the implication of the CJN stepping aside on the judiciary as directed by the federal government.
It is unheard of, it's unknown to law that when you charge somebody for a criminal breach, you come up again with a motion asking the court, a tribunal, to declare the seat of the CJN vacant, and then asking the tribunal to pronounce to empower the president to swear in his second in command. You cannot ask a tribunal, and it's a tribunal of that caliber, to declare that the Attorney General, that the CJN should step aside from his office, step down from his office, and then command the president to appoint another person. That's the strangest thing I've ever seen and ever heard. All with the authority and imprimatur of the Attorney General of the Federation. He signed and prepared those motions. They all came from his office. If the CJN resists as he appears to be showing right now, and the executive decides to use force, they may have their way, but the judiciary will not survive it.
Barrister Eric, however, implored Nigerians not to see the seat of the president as a do-or-die affair, and also hopes that God saves Nigeria from incessant national issues. Uchichi Nlemowa, TVN News.